So the data harvesting companies, I'll talk a little bit about some efforts to try to get them, to answer the question that was posed, to try to get them to actually remove information from their databases. There are laws that govern the use of criminal background checks. So federally, the Fair Credit Reporting Act is probably the big one. I think there's a misperception out there that the Fair Credit Reporting Act covers credit reports, when in fact it covers all types of consumer information that is being reported on a person. The Fair Credit Reporting Act then covers background checks that are related to criminal records and background checks that data harvesters perform. Interestingly enough, though, note that it's regarding data harvesters only. The Fair Credit Reporting Act, for example, does not cover when someone is doing an organic background check on their own. So again, the mom and pop type of independent employer who just goes onto the court's website and does some sort of background check, the Fair Credit Reporting Act does not touch that. We're talking about companies whose business is to report consumer information about people. Title VII also covers some of this. I put in parentheses that it's rather weak. Title VII claims can be very, very difficult to pursue. Title VII claims are essentially when you can show that the reporting of criminal history information disparately impacts certain populations. And so different parameters that a company may have in hiring will disproportionately impact a protected class, race, religion, gender, etc. So I'll talk a little bit more about that too. State laws that cover these types of the use of criminal background information. Generally, lots of states now have ban-the-box laws, which talk about what employers can actually ask in the application process. There's statutes such as first offender statutes. So California, for example, restricts inquiry into the certain kinds of expunged convictions. Once somebody has gone through some type of process to clean up records, certain state laws will restrict the use of that information. Generally, state laws are more comprehensive or cover more situations. They're more strict than the federal laws are, but not always. There's expungement statutes, of course, which govern the use of criminal background information. Minnesota, for example, has a statute that will cover any kind of misreporting of information. After something has been expunged, if an agency continues to report it, a person can have a legal claim or an action against that. So it's too big to summarize, but for example, I put Minnesota Statute 332.72, which regulates data harvesters under Minnesota state law, essentially saying that if a data harvester becomes aware that a record has been expunged, they are mandated that they will have to delete it. There's also statutes that mandate how often data harvesters need to regulate their or refresh their information. A lot of them are a 30-day deadline. Essentially, if they're going to conduct a background check or give a report on someone, that information has to be culled from the original government databases within the past 30 days. So there is an effort to at least get accurate information and to have it be something that's not just a repository of old information conducted at some point in the past that's just sitting there. So the Fair Credit Reporting Act. It governs all consumer reports. So again, I talked about that there's this misperception that it covers credit reports, but really the actual definition talks about consumer reports, and it says, a consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or in part for the purpose of serving as a factor in establishing the consumer's eligibility for credit or insurance, employment purposes, that's the big one, or any other purpose. So as you can see, the Fair Credit Reporting Act is actually quite broad and covers all types of information that might be reported about a person. The language talking about general reputation pretty much encompasses just about any purpose that you can imagine. So, and we talked about the fact that FCRA does not apply to any sort of organic search. So we're talking specifically about data harvesting companies here. So FCRA regulates the use of this information. They regulate the process for gathering information in a couple ways. There's a couple requirements that employers must follow if they're going to use a data harvesting company to run their records. So for example, the employer must obtain authorization. They must actually ask the applicant, is it okay for me to run some sort of background check on you? a lot of times they have to get a signed release allowing for that information. The release is dual-fold because a lot of times the government agencies, in order to give some additional pieces of information beyond what's publicly available, the government agencies themselves will need some type of a release signed. And so the release not only acts as in compliance with the Fair Credit Reporting Act, but also sometimes can give additional information from the government agencies themselves. It will allow the disclosure of additional information. So disclosure, an employer has to actually provide a notice, a written notice to the employee saying, we are going to conduct a background check on you. They have to also give pre-adverse action notice. So if they're going to take action on a record once they finally receive someone's report back, they have to provide some notice saying, you know, we're going to take this adverse action. I think a lot of employers, in my experience, fall down on the job on this one in particular. A lot of people that I talk to say, I applied for a job and I never heard back. I signed the releases, I allowed them to conduct a background check, and I simply got a notice back saying, I'm sorry, we're not able to offer you the position at this time. This, to me, like I said, is probably the biggest way in which employers fall down on the job and perhaps violate FCRA. Accuracy. The other thing is that the reports must be accurate. So the agency itself, the data harvesting company itself, has a duty to make sure that the information that they're reporting on people is actually accurate.